Yes, my name is Philani Lithandane Ndlovu. Welcome to my lecture on substantive law and procedural or adjective law. We are looking here at the distinction that is often drawn between what are known as substantive law principles and those that are known as procedural or adjective law principles. As we go deeper in our lecture, we are going to discover what practical purposes this distinction serves. But before we do that, we will try to contextualize the discussion by defining what we mean by substantive law as well as what we mean by procedural or substantive law. I hope you will find this lecture informative and fruitful, and then you will also share it with your friends so that it can continue to enrich everybody else who requires this kind of knowledge. Thank you for taking your time to listen. As we have highlighted above, law is divisible into two main branches, namely substantive law and procedural or adjective law. By substantive law, we mean the substance of rights and competences protected by the law. We will look at that one as we go down further. And then by adjective or procedural law, we are talking about the law of procedure as well as the law of evidence. And the question that we would like to maybe ask and answer is, what purposes does the distinction serve? Well, there's an overlap between substantive and adjective law. E.g., in South Africa, the Bill of Rights the Bill of Rights in the Constitution states that evidence obtained in violation of the Constitution is inadmissible to prove any fact. You find that here we have a Bill of Rights which gives us the substance on the scope of the rights, and then it also contains an element of adjectival law, in the sense that it now begins to touch and refer to evidence. And then the other issue is that the right of appeal, which is a substantive law right, is also an integral part of procedural law. So you find that sometimes this distinction between procedural law and substantive law is not really of any practical relevance. So we are saying the theoretical distinction serves as a simplified teaching model than serving any other practical relevance. Of course, we have got some authors who are now speaking of a penumbra or twilight zone between substantive law and adjectival law. Here they are talking in respect of those aspects of the law which do not fit neatly into the traditional distinctions between substantive law and procedural law. But let's look at our next slide, where we try to explain and explore these issues further. Let us elaborate on what we mean by substantive law. This is the branch of law which defines legal relationships between subjects, that is individuals, or the relationships between subjects and the state. Here we are talking about the relationship where the state is a holder of public law competencies, or in the case where the state is a holder of private law competencies. Now we find that substantive law defines rights and obligations protected by the law, including the remedies available to those whose rights have been infringed. What are the sources of substantive law? It's the Constitution, the common law, statutory law, or the judicial decisions of the courts incorporated through the principle of stare decisis, or the legal precedents in cases with similar facts and situations. Now, examples of substantive law include the principles that regulate family relations, that is in terms of family law, matrimonial law, the law of property, the law of contract, labor, succession and inheritance, or the law of the trust or corporate law, as well as aspects of international law. It includes public and private law, as well as criminal and civil law. For instance, in civil issues, we have spoken about contracts and delicts or torts, whilst in in terms of criminal law, we are looking at the definitional elements of crimes such as theft or murder or rape, all these crimes that get to be committed by people from time to time. Now, substantive law also defines a delict, a contractual breach, or the definition of elements of a crime, as I've already stated. So, in summary, substantive law defines the rights. It spells out the rights in terms of their nature and their scope. When we say somebody is entitled to a certain right, what exactly do you mean? And what is the scope of that right? And so on and so forth. Procedural law or adjective law, on the other hand, provides judicial tools for the implementation of substantive law. So we are talking here about that branch of law which determines the methods, the steps, and the procedures that are adopted or employed in the enforcement of substantive civil or criminal law rights and remedies. It spells out the processes or the steps in the enforcement of rights, and you find that procedural law determines how the accused or the prosecution present their cases before the courts in pursuit of their rights and remedies. So if it's a case of criminal law or criminal procedure, we are looking at how police go about rather in arresting the accused, or rather the suspect, the process of laying charges and then bringing or arraigning the accused before the courts, and all those steps right up to prosecution, right up to conviction and sentencing. So those are aspects of what we call procedural law. And if it's a case of what you call these private law relationships, such as breach of contract or delictual remedies, then you find that procedural law determines the steps taken by the plaintiff or the defendant in the enforcement of their rights in pursuit of the appropriate remedies. So those steps from, preparing a summons, serving the summons, and then the processes involved, the exchange of the pleadings between the plaintiff and the defendant, right up to the trial stage and the pronouncement of the verdict by the court. So all those are aspects of procedural law. You find that it determines the jurisdiction of the courts, the access to the courts in respect of specific legal issues, and the legal persons in terms of the structure of the court. You find that different courts, according to their geographical limitations, are competent to hear cases or matters that have occurred in a specific geographical location. So courts have competence, which we call jurisdiction, to entertain matters which have occurred in their own geographical area. They cannot and they may not, for instance, entertain ideas, or rather the disputes that have occurred outside of their own geographical limits. So all those issues are aspects of procedural law. You find that it derived from the constitutional law, the statutes enacted by the legislature, etc. And then you find that procedural law encompasses aspects of procedure as well as aspects of evidence. So we really need to take note of that distinction. Procedural law, as we distinguish it from the law of evidence, both of course being aspects of adjective law, we find that the law of procedure encompasses criminal procedure and civil procedure. Now, by criminal procedure, we are referring to the rules, the steps, the processes followed in the resolution of criminal law disputes. That is the prosecution of maybe for theft, rape, murder. It deals with the public law matters whereby disputes are between the state and the holder, as a holder of public authority, and a private individual. For instance, you will have noticed that criminal cases or criminal law reports would actually cite cases as S versus, maybe S versus John, whereby S represents the state and then John represents the individual being prosecuted by the state. And then civil procedure, on the other hand, deals with the rules, steps, processes that are followed in the resolution of civil law disputes, such as a delict, a tort, a breach of contract, or maybe the filing of a divorce decree. All those are aspects of civil procedure, which also deals with disputes between private legal persons or the state, not as a bearer of public law rights, but maybe as a bearer of private law rights. For instance, when a state enters into a contract with an individual and then it breaches that contract, it is brought before the court not as a holder of public competences, but as a as a holder of private rights. So giving an impression that the state and the other contracting party have that equality before the courts. None is superior, as you would assume in the case of criminal law. A very important element of adjective law is the law of evidence, which looks at what evidence is. So it answers questions like, what is evidence? What evidence is admissible before the court? That is applying the criterion of relevance. Also thinking in terms of the types of evidence. There are different types of evidence. For instance, hearsay, oral evidence, pointing out previous consistent statements, how issues such as confessions and admissions are handled, and so on and so forth. So all those types of evidence are dealt with in terms of the rules of evidence. Issues to do with the burden of proof, whether we are talking about criminal law, criminal prosecution, or we are talking about civil proceedings. You're looking at who bears the onus of proof between the plaintiff and maybe the defendant. What about between the state and the accused in the case of criminal cases or criminal proceedings? So all those issues or rules to do with the presentation of evidence, how it is presented at the bar, and so on and so forth. Those are issues to do with the law of evidence. Of course, we've spoken about the quantum of proof, how much proof is required in order to, overturn the burden or the onus. That is to shift the onus from one person to the other, from one party to the other. So all those rules to do with the analysis and the weight attached to evidence, whether it's cogent evidence or it's not, right up to the point where the court reaches the verdict, that is on the basis of the analysis of the evidence presented. So we are looking here at the issues of the rules of evidence, which go hand in hand with the rules of procedure. So you find that in the court process, the rules of evidence and the rules of civil procedure operate side by side, as we are seeking to implement the principles of substantive law. So in the actual resolution of a dispute, you find that rules of the substantive law rules, as well as the procedural law rules, both tend to be applied side by side without exclusion, without really finding any reason to exclude one or the other. Finally, having looked at the distinction between substantive law and procedural law, we would like to summarize it as follows. Substantive law defines the rights and remedies available to the bearers of legal rights, while procedural or adjective law defines the processes, steps, and pathways that are followed in the protection and the enforcement of those rights. The distinction between substantive law and procedural law serves as a simplified teaching and learning model, as we have highlighted above, that in the application of these principles, in fact, they are all applied at the same time in the resolution of one case. But of course, the distinction helps us to streamline what must happen at what point and how, because substantive law defines, as we have said, what rights legal subjects are entitled to, but formal law, that is the adjectival or the procedural, it ensures predictability, so that even the accused or the defendant knows what to expect and knows how to prepare their defense, or while the plaintiff or the prosecution also know how to prepare their case and to prosecute their rights, the protection, to enforce their rights. So there's that certainty, that predictability of legal process that is made possible by our understanding of the rules of procedure and the rules of evidence. So we find that substantive and adjective law concepts are not cast in stone, since they sometimes overlap in their operation, and some scholars talk of this trichotomy of substantive, adjective, as well as hybrid or twilight concepts. So, as I have already highlighted above, the most important aspect of the distinction is just to serve as a working tool, but otherwise in the resolution of disputes, substantive and procedural principles are applied side by side to resolve the same issue. Thank you very much for taking your time to listen to this video. I hope it has blessed you. See you next time. Bye.